Just to let you know, the Layla, president of IRCT, wasn't able to show up this morning due to a family home issue. So she's asked me to do the introduction. It's good to see you, Leonel. Thanks for sharing this ACH call for a consultation. Very interesting. So thanks everyone for showing up. The purpose of today, I guess, is two things. As you have seen, the IRCT's Independent Forensic Expert Group has issued a call for support and for cases to support. And we wanted to take some time with all of you from the IRCT membership in Africa and around the world, as well as select partners that we have invited here to discuss a little bit what the Independent Forensic Expert Group is, some of the work that it does, as well as talk a little bit about and contextualize it within the Abidjan rules. So the CPTA, as many of you know, has just issued in October new standard operating procedures for the receipt and consideration of torture cases. Urgent actions, urgent appeals, this kind of things that Lionel and Roberto will speak about in a few minutes. And so we want to talk a little bit about what kind of documentation and evidence might be useful and perhaps within the context of how we might make appeals to the CPTA. So thank you very much. As many of you know, the IRCT, the International Rehabilitation Council for Torture Victims, we've worked on two principal areas of work. One is the rehabilitation of torture survivors, supporting the medical, psychological, as well as legal livelihoods, economic and support and rehabilitation of torture victims. And the other area in which we do extensive advocacy is in documentation and investigation of torture. So this is, and as we will discuss, one of the core areas of work for the IRCT and something called the Independent Forensic Expert Group, which is a group of 42 forensic experts coming actually from the membership, as well as external experts from outside the membership from 23 countries in the world. The group has existed for 10 years, and it is actually the only international forensic group or group available to civil society organizations around the world more openly or broadly that accepts and receives requests for support for cases. The review of documentary evidence, such as photographs from protests, videos, other things, sometimes, review of testimonies from individuals who are in detention, photographs, different kinds of issues, and the medical legal evaluation, both in person as well as remote, of alleged victims of torture to support their claims, both to support legal claims as well as to support advocacy. Now, what we're going to do in the next, this is set for 2 hours, but really shouldn't last more than an hour and a half, where we can see how the conversation goes, is to do a couple of things. I'm going to speak very briefly about, forensics and what we mean when we say forensics and what is really the value of forensic expertise, so-called. Then afterwards, my colleague, Georgian, from the Independent Forensic Expert Group on the steering committee. He's waving his hand. We'll talk a little bit about how the Independent Forensic Expert Group works and how forensic assessment works. After that, Dr. Uju Agomo, president of PRAVA, based in Nigeria, working in Nigeria as well as many other African countries, will speak a little bit about her experience in using evidence in advocacy. And then Roberto and Lionel will We'll then talk a little bit about the Abidjan rules that the Committee on the Prevention of Torture in Africa has just released, as well as what kinds of evidence and documentation will be helpful or useful for the committee in order for them to take action, as we have been in both FIACOT and IRCT, among other organizations involved in the development of these standard operating procedures, and then hopefully we'll be involved together with you in trying to engage the CPTA in accepting and reviewing torture cases. So with that, I'm just going to make a few points. And the first one is to address the issue of what do we mean when we say forensic evidence or forensic interpretation? And how is that useful? So I guess particularly what I would like to address is really how is forensic interpretation different than regular human rights documentation? Some of you may have seen about a year and a half ago, the IRCT released a report reviewing 50 random cases of about 2,000 cases of alleged torture and ill treatment that was documented in Belarus. I guess everyone has seen the news about Belarus and the protest that occurred subsequent to the elections or the flawed elections and the re-election of the current dictator, strongman. So we were asked by local NGOs to review 50 cases, randomly selected of a pool of 2,000, and provide a forensic expertise on them. What does that mean? That means the first level, Georgia and I, and he will speak more in a little bit, but Georgia and I received case files from these 50 cases. What was in the case files? They were interviews, right? There were medical documentation. So many individuals following release from prison and beating went to their doctors and got doctors' reports. Many of them were severely injured. They got other medical records, so on and so forth. We also received some videos and we received some photographs. And we were asked to sort of review these. So what did we do? Well, the first thing, obviously, that any NGO would do is to review the documents and to compare and contrast all of the stories, right? So what happened in each of these 50 cases? What do we see? What are the patterns? Okay, 80% of, or 90% of people were being detained across 11 cities in 15 different detention facilities. 40% of them alleged that they were suspended, that they were tied and hung or suspended, right? 80% of them were beaten, right? This sounds very normal, like a regular human rights report. 20% of them were electrocuted. People complained about what types of injuries. They were bruised. They had, many of them went to see medical support. 15% of them were hospitalized. Okay, so that is the first level of, let's say, interpretation or analysis that we conduct as a forensic expert. Now, what is the second level of forensic evaluation? So in each of the individual cases as well, and I think this is where, there are two different levels. This is where it departs from regular human rights documentation. The first is that in each individual case, we conduct an assessment of the consistency between the individual specific allegations and the existing evidence, right? So in each individual case, the forensic assessment adds to the, let's say, the weight of evidence or the credibility of an individual specific story. So we can say, okay, we have these 50 cases. There is this kind of similarity between all of their stories. There's this kind of similarity between all of their allegations, right? But now in 80% of cases, for example, there is a high level of consistency between the evidence presented to us, both the documentary, right, the medical records, photos and even within the internal story itself, there's an internal consistency that provide strengthened evidence from a scientific perspective to the individual story. And in 85% of these stories, I think it was, there's a high level of consistency. And 15% of them, the stories are still consistent, right? So that is the second level of, let's say, forensic expertise, and where it departs from regular human rights documentation. And then from that, there's a third level. What is that third level? The third level is after assessing each individual story. Okay. After assessing, right, all of the allegations and comparing and contrasting them, after assessing each individual case and based on the evidence presented in each individual case, we were able to conduct an assessment of all of the evidence together. Now, why is that valuable? Because based on an assessment of the evidence, right, we can look at all of the photographs, for example, separately, and together. We can look at all of the types of injuries, and based merely on the evidence and injuries, then we can make determinations about the pattern and practices or the policies that may be in place. Because, for example, with the Belarus report, we can say that, okay, in 15 detention centers across 11 cities, looking at the injuries that we see, right, the patterns of bruisings are actually virtually identical, right? So each of these individuals, these 50 individuals, had a specific pattern of bruising, actually across their backside, their lower thighs, that is identical. What does this demonstrate? This demonstrates a specific systematic policy of torture and ill treatment, right, that is learned by police stations in Belarus across 15 detention centers across the country. We can then make determinations, we can make statements. Actually, the finding of the report was that there is compelling evidence of a coordinated policy and practice of systemic torture, right, based on the physical and psychological or the documentary medical evidence that exists, right? So even without knowing, right, the first level of interpretation was comparing all their stories, and the third level of interpretation is comparing all of the evidence. And even without these stories, in fact, without the allegations, we can understand what the similarity between the stories and what is being told. And so that those are really the three different levels of or forensic perspectives that we can take to evidence that is presented, right? Which makes it, and that's what we mean when we say forensic expertise or forensic evaluation, and why it adds something to regular human rights documentation and human rights investigation. So that's the first question, I guess. The second one I'd like to answer is what is forensic evidence? I mean, that was an example of a comparison of 50 cases, but in the individual case, what does forensic evidence, what does it answer? And what is it supposed to answer? I'll give you an example. In March of 2018, the Independent Forensic Expert Group, we actually conducted medical legal evaluations in Senegal of two journalists, two Gambian journalists who had fled there, right, from Gambia following torture to Senegal, and had been living there for over 8 years. And finally, 8 years later, they decided that they wanted to file a case to the Economic Community of West African States Court of Justice, the ECOWAS court. So we were asked to do a medical legal evaluation. And very often, even now, I mean, even with our longtime partners, and we have many longtime partners that we work consistently with, both national, like Prava, as well as international, like Human Rights Watch or Amnesty International. And even when we usually get evidence or cases, or we're asked to intervene, the question is simply, tell us if they've been tortured. Okay, was this person tortured or not? Do these photographs show that they were tortured, right? But the reality is, and I guess this is that the value of a medical legal evaluation is much more than, or should be much more than, telling us if the individual was tortured or not. So, for example, with this ECOWAS case, the purpose was, I mean, because I don't think anyone really, I mean, the court would never actually say that. I mean, the ECOWAS court we know is one of the more open and progressive courts in Africa, right? They have entertained many cases filed by NGOs, in fact, and they have even taken cases filed on the basis of torture, right? But what we needed to, or what we wanted to explain, was two things. Why did it take this individual 8 years to finally file a case? And how do we demonstrate that he's still tortured, even though the guy's already living in Senegal, which is, right, by most accounts, if you've been to Dakar, a much nicer place to be than in Gambia. So through the medical legal evaluation, we were able to demonstrate that, in fact, the individual's psychological state had been getting worse, that he had been in Senegal for almost 6 or 7 years, 8 years, and he was psychologically deteriorating because of the loss of social links, right? Because of the loss of, he was a very well-esteemed journalist in the past, because of his separation from his family, because the fact that, he often had to skip meals, right? Because he couldn't afford to eat. That his PTSD, right, his psychological trauma was actually insisting and was actually becoming aggravated, even 8 years later. We were also able to demonstrate that he had many psychosomatic issues, right? That he had many physical problems, many that seemed to be linked to the specific torture acts, but many that were not. And because of it, the ECOWAS court, as some of you I think know, became one of the first international courts to finally rule that forced exile is a harm or injury that results from torture, right? So the fact that one has to flee and the subsequent injuries or the subsequent trauma that one experiences, even when they are in another country, is a specific injury that results from torture and should be remedied as part of the Torture Act. So in many ways, the medical legal evaluation itself is not just about, is the person tortured or not, but it's meant to add value to and help the court and others understand the experience of torture, right? Ironically, I guess, in preparing for this talk and just reviewing my notes and the cases that we've done, I've discovered that in many, like with the ECOWAS court, suddenly we issued this issued the medical legal reports that were entered into the court, and the headline says, okay, new evidence that proves that these individuals were tortured. Very often when we issue reports for human rights or others, the headline says, okay, new evidence that these individuals are extrajudicially killed. And we keep calling this kind of forensic evidence new evidence, when in fact, we know what happened, right? In many of these cases, it's clear that the individuals were tortured, but it's new evidence because what it adds is new understanding or new information. It's not really, what is not new is just saying, okay, these individuals are extrajudicially killed, right? I mean, the journalists know that, everyone reads the newspapers, we all sort of understand that. I mean, no one doubts that, I think, in Nigeria, with the SARS police, these victims of the SARS police, no one really doubts that they were actually tortured or ill-treated, right? So the newness of the evidence is in the information and the understanding that is conveyed and provided. And that's what really makes the medical legal evaluation powerful. It's not just in having a bunch of doctors with a lot of, MD, MPH, PhD, et cetera, acronyms behind their names come and say, okay, this individual was tortured. I mean, that's very impressive. But it's actually in adding perspective to the torture experience. The last point I will make, and it's very short, is the independent forensic expert group. So what is it and what's the value of it? So like I mentioned, the independent forensic expert group is an entity. It's 42 individuals, 42 forensic experts, and these are some of the most experienced experts in the world on the documentation of torture. This is all of the principal drafters of the Istanbul Protocol. As many of you know, the UN manual on the investigation documentation of torture, so the key international standard, which was just revised in June. And most of us are part of have been part of this project or been leading the project. This includes former chairs of the Committee Against Torture, a couple of special rapporteurs, a couple heads of training for the ICRC, the current scientific head of the scientific advisory board of the International Criminal Court, right? So this contains prominent individuals and experts. But what makes the IFEG valuable is that the IFEG exists the same way that the IRCT exists, or the same way that FIACAT exists or OMCT exists. It exists as a body. So when it issues opinions, it doesn't issue them just as individual experts. It issues them as a body of 42 experts who have collectively evaluated over 50,000 victims of torture, right? Who have collectively actually issued and published over 2,000 medical, legal, or forensic scientific articles, who have collectively actually conducted 1,900 trainings on the Istanbul Protocol around the world, who have a collective experience of, I believe, 600 years in the documentation of torture. Right, so the IFEG exists as a advocacy body the same way that OMCT exists, or FIACAT exists, or the IRCT, both in speaking as individual experts, but as a body. And that's valuable. That's valuable because when you work in a national context, for example, the local courts, they don't know who, Georgia Alampievich, he's going to speak very quickly. Georgia is very famous in Serbia. He's the head of the forensic department of the University of Belgrade. He used to be the CPTA. But in Nigeria, no one really knows who Georgia is, right? So the IFEG is valuable in in speaking as a body, and even national courts, right? It's possible that even in a national court, they don't necessarily know who, a local court somewhere doesn't know who Georgia is, right? Or even the Bosnian court might not know who he is. So the IFEG is valuable in actually issuing reports as an international body itself. And that becomes important both at the national level and the international level, because it's having the body that allows us to interact with, let's say, the CPTA, right? The same way that the IRCT also interacts and coordinates with the CPTA and others. So I think I'll leave it at that. Do we have any questions, or does anyone have any questions or thoughts? Anything they would like to share before I pass the floor on to Georgia?
We have a hand up by Andres.
Please.
Maybe that's not.
Please, Andres.
Andrés, ¿tienes alguna pregunta? Está muteado, Andrés, no lo escuchamos. Andrés, está muteado, no lo escuchamos.
Oui, voilà. Vous m'entendez?
Oui.
Vous m'entendez? D'accord. Cher James, j'aimerais juste faire une observation parce que de mon point de vue, ça prête à malentendu. Quand on parle d'investigation médico-légale et on ne mentionne pas l'aspect psychologique, parce qu'il s'agit, avec le protocole d'Istanbul en particulier, d'études psychomédico-légales, ça prête à malentendu. C'est comme si le médecin, pour être médecin, parce qu'il est médecin, il est déjà psychologue. Et c'est une erreur. Et je dirais qu'il faut parler d'investigation psychomédico-légale et pas réduire toute l'investigation au niveau médico-légal. Merci.
Thank you. Thank you for the very important point of clarification. I mean, the forensic evaluation is both psychological and medical. It includes a review of both psychological and medical evidence, right? And the psychological, as in the case of Gambia, like I shared, is equally or often more important. So, any other comments or questions before I pass on the floor? Okay, Georgia, now that they know you have all these, PhD, MD, acronyms behind your name, they want to hear you speak.
And all my slides on, I cannot do as you did because, you just show on screen and everything is crystal clear. So I have to resort to this technology, to back up what I will be talking about. And first of all, good afternoon or good evening or good morning, everyone, depending from which time zone you are following this webinar. And I'm really glad that I'm able to address issues of independent forensic expert group and just to bring to your attention who we are, what we are doing, and what you may in future expect from us, and what might be the points for cooperation. So please feel free to ask the questions, as unfortunately I will need to leave this webinar in about 30 minutes. So after my presentation, if you want to ask something, please go ahead. So James has already, he had said some words about what we were doing in terms of Belarus, and I will continue that story and explain in more details our activities regarding crisis in Belarus and the developments with the IFEC. But just to bring us all back to the early beginnings of IFEC, this gentleman who is presenting here is Onder Oskalipci, our dear friend and colleague, who is also in this group today. And this is how Onder was chasing people to start this group, and it really now brings fruits, So we have done a lot, and I will show you figures. So you already know who we are, and we are coming from different countries, but it's important, and it's also to address what Andres had asked just before I start my presentation. So we have different backgrounds, and we are not as a forensic doctors doing assessment of psychological aspects. So for that purpose, we use psychologists or psychiatrists. And unlike that situation, so psychiatrists and psychologists, they are not looking after injuries. So we work in a team, and that's the essence of Istanbul Protocol. So because you cannot separate physical and the mental aspect of one's well-being and health, of course. This map needs to be updated, as meanwhile we have pioneered some more countries, but it's even visible from the map. These countries that are colored has been visited by by teams of the IFEC members so far. And the number of expertise has been provided, and they were submitted. Medical legal reports were submitted to national courts, but we also tend to focus on cases that are going to be brought into the attention of regional and the other mechanisms for combating torture and for providing justice to victims of ill treatment and torture. And we also do, and I'm inviting you to find some of these articles. We are preparing statements, like you can see here, on conversion therapy, anal examination, etc., etc. And we are publishing these statements in a peer-reviewed esteemed journal of torture prevention and forensic medicine. Why we are doing that? It's also the way to update and to put a sort of to gather the existent knowledge and to do a research on the topic and to present it in a comprehensive manner in one article, which can be then used also to support some of the positions of the IFAC, but not only IFAC, but the other forensic doctors or human rights activists who are facing similar problems, regardless if they are living and working in Africa or in Europe or in some other continents. So, and what we are also doing, for instance, it was 3 years ago, 3 or 4 years ago, it's coming to be 4 now, I was myself a member of the IFAC team who had visited Uganda for medical legal reporting. So we have examined several people who claim that they have been ill-treated. But we used that opportunity because it was a very, very long way. And of course, it was a very expensive operation. I mean, all these logistic costs. And then we took that opportunity once we were in the country to provide some training to local NGOs, members of the IRCT, but also to raise awareness and to do some advocacy. So that's way to economize and then basically to kill two animals with one shot, which is also good. What we can also, and what we are also doing, these are desktop studies and consultations. So if you have a problem or if you are not sure how to let's say, manage situation or problem that you are coming across in your activities, you may feel free to contact the IFAC either directly or through the IRCT or local IRCT partner. And then certainly you will have a response. And if we can help, of course, we will do assessment and some recommendations, like in this case, in which Human Rights Watch had approached us, to provide to provide consultations on situation in Brazil regarding police killings on the streets. But now let's go to activities in Belarus. You have already heard about what we have done there, but it's interesting just to tell you that at the beginning of crisis, early after presidential elections, which took place in August 2020, it was an outbreak of public unrest, and it was massive throughout the country, as James already said. So we came in touch with our local partners and with human rights organizations from Belarus, and then we understood basically that there were several NGOs who were doing its best, to help people who were in trouble. Many of them has been beaten, numbers has been arrested or were facing detention. And there was a lack of coordination in between NGOs, and that was the problem, how to collect data on police atrocities. And this is what we understood early in our contacts with our local partners, and then we decided to empower them, to try to unify them in this situation, which was really a problem. It was threatening to overwhelm their capacities. So we have offered them a training. It was online. Certainly in such situation, it would be not possible for foreign experts, and it would be very politically sensitive to get into the country. And on the top, it was pandemic. It was a peak of pandemic, so it was also impossible to travel. And thanks to all these technological tools that we have now, we can work really very efficient from distance in some situations. So what we have done, we put together several organizations, and we provide them with the training. So we have also asked our colleagues from different organizations, like you can see here, from PHR, for instance. So they trained how they were documenting injuries. Our dear colleague Shebnam Fincaci from Istanbul, president of Human Rights Foundation of Turkey. So she delivered the presentation on how to collect the evidence on spot, owing to own experience from massive protests in Istanbul that took place a while ago in Turkey. Then there were other people also who were talking how to improve and enhance data collection, or how to collect data from places of deprivation of liberty, from police custody, from remand prisons. Then it was very important, because people are thinking, even those who are engaged with the NGOs, and you can even think of lay people, I mean, people who don't have any exposure to human rights violation, I mean, managing of the cases. So people think that it's enough to take photo. Of course, it's better to take any photo than no photo. But whenever you are in a position to improve the quality of photo, to put ruler or to do it according to some rules, then it can make best use of it, you know. And that was the topic of the presentation of our colleague who was able to speak commonly known language, namely Russian. So this title slide is in Russian. So an overview, this group of people who are coming from different countries can contribute with their own expertise, because problems are more or less similar around the world. You know, context may be different, but and therefore this extensive group of experts can really help and intervene. And also, we understood that different organizations who were really doing their best are collecting data on different formats. I mean, they were doing it in the way how they best can. And then we realized that it's better to try to unify them among a sort of protocol or standardized form. And we have developed very quickly in a couple of days sort of guideline and in the form you can see here, and then you will be able to have some slides, I mean, if you want. Just to say, okay, so this would be absolutely minimum how to collect data, and that was also a form that can be filled in by victims themselves, you know. So that was aimed to decrease the pressure on NGO activists, because we are talking about dozens of people who has been beaten on a daily basis. And this all, so we have somehow invested our expertise in early beginnings, which brings the fruit at the end. And these fruits are printed and published in our report. And as James said, so we really believe that our intervention helped to improve the quality of documents that has been collected by different NGOs on the spot, and later on submitted to our attention and analysis. So these are photos that we have received, some other medical files, etc. And I'm coming to the end of this presentation, so you can see in figures, and really we have good reasons to be proud of what has been done. But despite of these nice figures, and we are we are full of energy and we are uptaking new activities and thinking of future. And we will be very happy also to cooperate with your organizations in the future. And it's important that we should never give up, and even and that will give some results, I believe. So thank you very much for your attention, and I'm opening floor for the discussion.
Thank you so much, Georgia. So, do we have any questions or comments? That anyone would like to make?
That Eva, I see one hand raised. So
hi.
Eva?
Yes, hi. Thank you for the presentation. I am Eva Nudd, and I am the legal advisor with Dignity. And I recognize most of your faces, even though I have not met you in person. And I was one of the drafters on the Abidjan rules. But my question to you is actually, do you have any data or statistics on the collection of the documentation done by the victims themselves? Because the form that you previously showed is very good. But I live in Kenya and I've been working in Africa, and most of the victims that I have worked with would have a really hard time filling out the form. So do you have any data or anything to show how successful that self-identification or the self-form filling out as a victim has been actually in Belarus or other countries that you have had deployed it?
Absolutely. Thank you, Eva. That's a very pertinent question. Though I cannot offer you, unfortunately, a straightforward answer, as actually this questionnaire was created by us in cooperation with local NGOs, and then it was distributed by local NGOs in country. As I mentioned, we haven't been there. And they were collecting the forms once they were filled in, and basically they were then somehow submitting cases. These 50 cases which were mentioned by James were submitted and selected by local NGOs, not by us. So it was not a situation that we have had a huge database, I mean, through which we can, for you applying certain criteria, select the cases. And therefore, I cannot give you a figure on response rate. And I understand that in some context, especially in rural areas, it might be difficult because people are illiterate, or I mean, they cannot, or there are other reasons that they cannot respond. But we have created this really for that time situation in Belarus, because activists of the NGOs were overwhelmed by a huge number of people, and they cannot conduct interviews. I mean, they can, but progressing with one client, I mean, they put several clients on hold, and some of these clients will give up, waiting, because I mean, that's take it or leave it. And the idea was to collect as much data as possible, but also to have it in a format that allows for easy comparison of data. You just because this is more like check-in, tick box, and so on, which gives a possibility for such analysis. But for any context, I mean, this can be developed or redesigned and used, and that will be an interesting study, as you said, to see what would be a response rate in some other context, of course.
I guess just to add one thing, thank you, Eva. That's, the forms themselves, they of course they're very challenging to use. I mean, like actually, we're going to talk about the Abidjan rules, right? Hopefully a bit more, so we can talk about it, because that is really the challenge, right? That was the challenge in the development of figuring out what to ask. And it's that kind of thing where okay, we can ask minimal information, but it's also clear, we have spoken with some of the CPTA following the launch of the SOP rules. And it's also very clear that, the more documentation, the more evidence they have, the easier it will be for them to engage with states and with governments while they talk about, okay, we have an allegation and, people say that they're torturing. Well, it's easier for them to have that kind of interaction, both to appreciate the situation, appreciate the specific situation of the individual, but as well as, right? So that always is a challenge. The forms themselves, they weren't, as Georgia mentioned, they were developed for Belarus. We have shared them, but we haven't actually, shared them in a way to say, okay, now we have there's a protest in Turkey here, try to use this form. And that would be something I think we've been exploring. They're also meant as educative tools. They're also meant for NGOs and others, right? They're actually very much developed based on our experience working with NGOs and others, right? Because we receive and we work on around 20 interventions a year, right? And so even in Belarus, actually what was happening very often is when we were actually reviewing individual cases as well to support some individual complaints. And every time we would get information, even actually from the interview from the lawyer, our response was actually, well, here's this form that we've developed, that we prepared. Please fill out sections 2, 3, and 4, right? One of the biggest challenges, for example, was that in the review of cases, actually, was that the medical documentation, as I said, it was great that individuals were going to see their doctors. They were so injured. It was horrible, but anyhow, they had access to doctors, so they were going to see their doctors after they left prison. They were going to see their doctors. They complained about, a full day of being beaten. There are videos about what happened. But then when you look at the medical reports from their doctors, it would say, 1 hematoma, purple, 2 inches, left thigh. And actually, Georgia and I, after a while, we realized we were getting the really bad cases, like the individual cases. They were sending us the most difficult cases because they weren't sure what to do with the evidence, because it seemed like from the medical reports that in fact, the victims, they were contradicting the victims' horrible allegations. Right. So part of this form that we shared, for example, has this kind of information that's necessary. How long was the actual evaluation by the doctor? Right? Was it like 5 minutes? Was it an hour? Did you actually take off your clothes? Right? Just very basic things. And so actually for every individual case we reviewed, we had to send this form to the lawyers and say, please fill out, sections 1, 2, and 3, because these are the questions we need to make sense of the information that's being provided. Right. So in that way, they're also meant for the lawyers and the NGOs to apply in understanding. So it was really meant as that as well. And as well, I will pass on right after this, but I think it is important to note, it's also just meant to have for the information and understanding to be out there. The reality is, victims don't know what to document. They don't know what they're supposed to say to people. It's to make the information available and public, right? Whether or not, right? Because otherwise, just to, in some ways, to break this kind of monopoly that, frankly, NGOs have, right? Like you have it, we have, right? NGOs, we sort of have a monopoly on sort of information about, okay, what are we supposed to do with the torture case? Oh, how do we do international advocacy? And it's to ensure that at least the information does exist for the public and for individuals who go through these experiences, to know how to tell their story. So that's really just, but yeah, please, Evan.
I was going to say, so the reason why I ask is, and your explanation was perfect, is we are building up a project in Burkina Faso on documentation of torture and ill treatment. And a lot of our victims will actually be in areas held by the militia. And a lot of the human rights defenders will absolutely have zero access to these victims. And so that's why I wanted to see how in practice it had worked and see how I can incorporate it into my own training in a couple of months to make sure that we reach as many people as possible in Burkina, given the difficulty of the context that we are operating. So thank you for the explanation, James.
Yeah. I mean, some things might help, but sorry, Georgia, did you?
But you have to be cautious because here we aim to examine the context, not individual cases. If you want to do individual cases, then of course, and to collect the evidence for, let's say, court, etc. So then it might be very difficult to use this approach. As you might saw on the slides, though I was browsing quite fast, there is a body diagram, and victims were invited to draw on their own, like a bruise here, cut, laceration, etc., and to supply photos on their own, either selfies or photos taken by, I don't know, friends, spouse, whomsoever. But we, from the very onset, we knew that we will be dealing with the context, not with individual cases, because it will be very difficult I mean, that cannot be a substitute for proper examination if you want to deal with individual cases.
Thanks for that. Yeah, anyhow, it would be great to be in touch and to discuss this further. I think it's very interesting. So yes, Andreas, you wanted to make another comment, please?
Oui, tout à fait. Oui, oui. Vouloir travailler avec des formulaires, je pense que c'est une aberration par rapport au but du protocole d'Istanbul. Parce que c'est un acte, l'acte de dénonciation est un acte humain fondamental à qui il faut prendre toute l'attention de la personne et bien sûr, si c'est le Burkina Faso, de voir les possibilités d'expression de ces personnes. Et c'est évident qu'un texte écrit, de toute façon, n'a pas de sens, mais ça, c'est pour n'importe qui, parce que l'espace de dénonciation est à la fois un espace psychologique, parce que si la personne veut dénoncer, c'est qu'il veut dénoncer une humiliation, il veut retrouver son honneur. Donc, c'est un processus psychologique d'interview fondamental où l'écoute et l'adéquation aux formes d'expression culturelles sont fondamentales. Merci.
Thank you, Andres. But yeah, I think you're, as I guess for context for others, Andres is talking about the medical legal evaluation process, but the forms themselves are not meant as medical legal evaluation. If you look at it, you'll see they're meant as documentation, right, for individuals to use, and very much the same way they would do human rights documentation or investigations for investigators to use in the field. So it's a little bit of a different context, but of course, the medical legal evaluation, as we've mentioned already, the meaningfulness is to understand the individual story and its comprehensive complexity. But unfortunately, I mean, we're trying to get courts and others to appreciate that as well. So excellent point. I note there's two questions in the chat box, but they're more of a broader general nature. So I would propose let's move them to the end if we can, Vasiki and Juma, and then move on to the presentations by by Uju, and then Lionel, and then Roberto, and then we can talk about the two more general questions as well about how we know when an individual is a victim of torture in a protest scenario, and specifically related to the gaps in implementation mentioned by Fasigi at the end, perhaps also in the context of the CPTA and how we engage them. Does that work? So if we don't have any more hands, then Uju, floor is yours. Thank you.
Thank you very much. Thank you very much, Jane and James, and thank you indeed everyone who have found time to sign in to listen to the panelists. I think this session is a very important session because it's helping us to understand what tools and mechanisms that we have out there. It is also helping us to begin to articulate how best we can work with what is available to ensure that the work around providing rehabilitation and support for victims is really progress as much as we can get it to progress. So I would start first again to comment IFEC for what they're doing, and I was really quite impressed when James was ruling out all the cumulative capacity that resides with that team. You know, it's not only that they have 42 experts, it's not only that these experts are coming from close to about 23 countries, but he said something about them having about 600 years cumulative experience, yeah, and then talking about the number of cases they've handled personally, the number of persons they have trained, number of articles they have written, which indeed tells me that we do have a very important mechanism and team that we could look at ways of engaging a little bit much more than perhaps some of us in Africa currently are doing. And thanks also to the possibility of the work that have to be driven with now the Abidjan rules and the possible collaboration that will ensue going forward. My own focus is to bring to bear the beauty of documentation in terms of advocacy. So, but before I do that, I want to first of all remind us about the United Nations Convention Against Torture, Cruelly, Inhuman, and Degrading Treatment or Punishment, the UNCTAD document itself. You know, in Article 1, it tells us clearly what the definition of torture is. And, you know, each time I go through, I see so much strength and content within that definition that can actually promote several kinds of work. So if you look vividly at the content of that Article 1, you will understand the first one of the key things that was mentioned is the fact that torture, whether psychological or physical, there is also the notion about this being pain or suffering. So, of course, this has to be seen in terms of who the perpetrator is, you know, somebody who is acting in terms of official capacity, and also ensuring that this is not same as sanction or punishment coming up from any criminal process itself. So on the face value of even that Article 1, I tell you that in terms of the proof that the documentation process will pursue should be able to help us establish that what we are capturing here is something that can be classified as either physical or psychological torture. That what is being captured here is something that can also be shown that this person has gone through pain, and this person has gone through some form of suffering. So I think that one of the critical issues that we found is that evidence is very powerful. And anytime we're able to capture this and bring that to bear in our advocacy, it makes our advocacy quite strong. So it's no longer the fact that you are speaking because you want to speak, or you are asking that the country should stop torturing, or you're mentioning that victims should be rehabilitated and supported or compensated. It's not just because you're saying it because you feel like saying, but you have a proof to show up for it. Now, we have about 173 countries or state parties that have keyed in onto this. And I think maybe about 22 more state parties that needs to join to have universal, ratification of the UNCTAD, okay? So one thing is about signing and ratifying a UN convention, or indeed in law. The other thing is, what are the key steps that have been taken to implement? And I found that over the time, many countries, many member states of UN have failed to have this process of making sure that the implementation of what has been signed is really the issue. And I think it's really done. So I think that documentation provides us a very important process to be able to actually hold the country accountable, to be able to say, this is exactly the proof of what has been done. And this is actually what we can argue in terms of what will be the response of the country in terms of when we can show proof, pure evidence as to something that has gone wrong. Now, let's also remember what is said in Article 13 of the same United Nations Convention Against Torture, Cruel, and Inhuman and Degrading Treatment. Clearly, it says that each state party shall ensure that any individual who alleges that he has been subjected to torture in any territory under his jurisdiction has the right to complain and to have his case promptly and impartially examined by his competent authority. So the notion of being able to have documentation of what has happened in a standard format provides an opportunity that will enable, this process that will help us guarantee this to some extent. So this is really what happened. The fact that a lot of people may tell you that they've been tortured, but if you are not able to capture these details, it makes it more difficult to prove the case. So I give you an example. 2020 in Nigeria, we had a situation where there were widespread protests against what is called the Special Anti-Robbery Squad of the Nigerian Police. It's called SARS for short. So a lot of panels were set up. One of those panels were the ones set up at the national level by the National Human Rights Commission. And of course, there were many other states that also set up panels. I happen to be a part of the members of the panel for the one that was set up at the federal level. So as cases were coming up, one of the key issues here will be evidence to prove that this person who has said he or she have been tortured, that this really happened. And I tell you, where those cases were easy to be proved were often where you were able to have things that were probably documented, okay? Where we had evidence. Sometimes you had the experts coming, doctors, whatever, to give some evidence around what really happened and what they could say in regard to the particular wound or signs or scars that had happened. And of course, there were about 100 of those cases that were able to benefit, that came before the panel, that were able to benefit from one form of compensation, financial compensation, or the others. I want to kind of put us back to again why this whole notion of documentation is critical. First, you find a situation whereby it is not that this individual was not tortured. It is the question of, can this be proved? That's one. So the question here is, what are the things that will enable us to make this easy, to ensure that the process that can enable the proof to be provided, the evidence to be provided, is there. So one of the key things we found that was over time, there were no standards or no standardized format in terms of capturing this. Sometimes it's also a question of the persons, whether they be lawyers or the doctors, not being able to know what needs to be documented. So it is important that a standard format, which of course is one of the key things that is being provided, it's being followed, and that the professionals are able to be trained in terms of what they need to do to be able to capture or document the relevant things. The same thing for even rehabilitation centers, that you therefore know that these are the key questions to ask, these are the key things to put up, these are the key pictures that you needed to take, and this is what steps that needed to be done. I also think that beyond this documentation helping us to be able to deal with the individual cases in terms of the kind of rehabilitation that that person has, it is also something that provides opportunity for us to look at what the trend is. What are the trend analysis? And this becomes very powerful when you are dealing with the issue of advocacy. That you can say that over this particular period, we were able to find out that this issue was happening more with perhaps persons of a particular age group, or persons of a particular socioeconomic class, or persons who are located or in a particular area. And we can say that this is actually happening, or the perpetrators are mainly more persons who are based, maybe the police or any other. So I think that when we are able to find this trend, and it then gives us the tools that we can take on and then move on our advocacy. And what are the key advocacy points? And I will tell you some of the examples that we have had. So first, if you're looking at advocacy that has to do with legislative changes, you now see that it's important to begin to bring such information to the legislative committees, relevant committees of, for example, in Nigeria, we have both the Senate and the House of Representatives, to say to them, and within that, you also see committees that are in charge of human rights, committees that are in charge of maybe reformatory institutions, committees that are in charge of police, committees that are in charge of security, whatever that means, any of those committees that you find an entry point. Many of the times you find out that these committees themselves, they have private member bills that they will have an open hearing where people come in and make comments. And we have found out that each time we come for those platforms, and we're able to give concrete statistics, concrete evidence, flowing from clear documentation that we've made, it works, like, if I must use the word, like magic. So I think that this is a very powerful tool that we should not ignore. So again, for legislative reforms, that is important. Second level is that we'll also find out that when we take this issue in relation to discussion with high-level officers in relation to the particular agencies that deals with it. So, for example, if we're talking to the National Human Rights Commission, or we're talking to the Ministry of Justice, Ministry of Health, or you're talking to perhaps the Ministry in charge of Interior, where things like correctional services and or prisons, what is it, as prisons reside, or you're talking to the Controller General of Correctional Service, which is the controller in charge, or general in charge of prisons, as may be called in other countries. You find out that whatever agency that is, once you're able to discuss this with this agency and you are bringing facts and figures, that makes a whole lot of difference. A very recent experience for us was an issue that happened on the 2nd of this month. We had an advocacy visit carried out, which we made to the Minister of Interior. As soon as he saw the statistics of what we're saying, he became very, very interested in the issues that are being discussed. So again, this is quite powerful. So remember, I have spoken about where this becomes relevant in terms of legislative reform. I've talked about this in relation to dealing with ministries and agencies that have direct bodies. You also find this useful when you are trying to engage professional bodies, associations in relation to medical association of psychologists, association that is in charge of what they call Nigerian Bar Association, like Association of Lawyers, and it could also go even with associations that are like Association of Psychiatrists in Nigeria. It's called the APN. And indeed, any other professional association, you find out that it's not just about the legislators or the government angle, but you can also use it in terms of raising awareness with key professionals. We had a virtual session sometime last year, and we had doctors who had signed into that virtual session. And again, by the time in one of the sessions that we started discussing some of these issues and began to say some of what the evidence that we're getting from the field, we realized that some doctors began to then open up to say, this is what we are finding out in our day-to-day work, which aligns with what you are saying. And it was easy for us to have many of them sign up to serve as volunteers, okay, into the scheme. Now, I also would like to mention one other thing in relation to how powerful this can also be. How powerful you can be able to use some of these tools to be able to make certain levels of advocacy. So it is not beyond the points I have mentioned. I also find that even when we are doing clearly public awareness, which I've also found out that oftentimes the government agencies will not do much until they see that there is a media engagement on this. And what did we do? We had a network of journalists. This network of journalists, which were picked from relevant desks from a different media houses across the country. So we had a system where, first of all, we did a training for these journalists. And the second level, what we did was we started producing fact sheets between 2 and 4 pages on different issues. But these fact sheets also contain certain statistics, of course, coming on from trend analysis and all that. And of course, within those statistics, you are not being specific. You're not going to mention any direct victim. You are looking at mentioning the trend. You are looking at mentioning the key things you are seeing without necessarily mentioning any individual victim. But that was providing information to these journalists that they're now using to write stories they were using, and this to kind of push a lot of information out there. And what we were doing was to increase the quality and the frequency of media reportage on these issues. Now, what the journalists were doing was that the stories that and features that they would do for that period will focus on the theme of that particular month, or that theme, which is the theme of the fact sheet. So you find sometimes 5, 6, 10, 11, 12 of them in different formats using that. What that was doing was it was increasing the level of awareness on this issue out there to the policymakers. And I found that, in short, this is becoming very, very interesting. I found that oftentimes what happens is that the policymakers will not do anything except they think that these things were very much out there in the public space. And to make it more powerful, it is what you can use your documentation to do and be able to prove the point that you are making. Again, we also have found this also very useful when we begin to talk about sending reports, whether it is reports to National Human Rights Commission or reports to the African Commission, or reports to any of the other UN mechanisms in terms of either shadow reports or whatever it is. But whatever the major thing here that I must try to explain here is the fact that once you are able to have the documentation strong enough that you're able to capture what has happened, to be able to show really that torture had happened, that this is the degree of this torture happening, both and the nature of that kind of torture that has happening, how many people are being affected, and all the other demographics that can give to you. And then you're able to then utilize it in terms of your general advocacy. And as I said, that is one level. But again, on a more individualistic level, this also helps you even as a rehabilitation center, for those who run rehabilitation centers, to be able to deepen and strengthen the work that you're doing, understanding the content, understanding the kind of clientele that you are gathering more, and understanding what areas of capacity that you require more to build up, strengthen more of the interventions that you are having. So I have mentioned this, but I do want to say that why it is, in addition, important that we push this issue of ensuring that documentation, it's taking the medical legal documentation, is something that we all utilize, we all build that capacity, we all try to make sure that we utilize. Why it is important is that if we understand clearly that we need to support the victims more, beyond the points I have made earlier, because even the whole notion of re-traumatization that happens, once you find a victim who have not been supported adequately, just because this incident was not documented well, it becomes more problematic. And I think it's a question of doing more harm than good. In Nigeria, for example, the Evidence Act says something that it also aligns itself with one of the provisions of the UN Convention Against Torture, Cruel, Inhuman, and Degrading Treatment. That Evidence Act is saying that every person who had complained or he had proved that the evidence that is had against them, either confessional statement or whatever, was gotten through duress, through torture, through acts of duress, that evidence will not be admitted in court. So whatever usually happens that in that court, once this allegation has been made, all the matters end and they begin to start off what is called trial within trial. So it goes on another process, which is trying to prove was torture actually carried out. And I think that this is also another opening, because the more we can be able to strengthen this process and that early contact can be made, it becomes very helpful to also be able to make sure that these victims are actually being supported. And I believe that as time goes on, when the perpetrators begin to understand that once they are torturing people, that any evidence that they are getting, any confessional, so-called confessional statement in court they are getting will not be accepted more by court, and this will make their cases to fall. So I just wanted to say this and say that this is a very good process that we all need to build on. Member centers that do not have adequate training in terms of documentation need to be able to look at that and how they can utilize it, both for enhancing the provision of medical and psychological and social and legal support they provide to their clients that come, that the victims, but also they will also find ways of utilizing this in a broader sense to push for advocacy at the different levels, whether they be legislative advocacy or advocacy being done in terms of direct policy prospect.
Oh, Uju, sorry, but you're muted.
Oh,
Yeah.
sorry, I didn't see that.
Now again.
Okay, so I just was I'm about concluding on my point. I was just trying to say that this is really important. It is important for everyone, especially rehabilitation centers, to utilize both in terms of the enhancing the quality of service that the center is providing to the victims, but also by ensuring that they can utilize it in the kind of advocacy that the center may be willing to explore. Advocacy that can help in terms of improving on a broader level. And I have tried to share some of the examples of some of the advocacies we have carried out in the past. And that could be with legislators, that could be with relevant ministries of government, that could be with also professional bodies. But it's always very powerful to be able to look at this. And I must also say, finally, that the benefit of having IFEC is really something we should utilize more, because we can't get it any better. If we have this number of experts coming from these many countries, also with this cumulative knowledge base and experience in terms of utilizing the Istanbul Protocol, experience in terms of writing around this issue, it will also help us. Remember the point when I was reading Article 13 to you, when I mentioned the notion about impartiality. I mentioned issue about prompt, impartial, and competence. So that will help us. IFEC will help us meet this qualification. So if we want to have a process that will enable us argue that what we are bringing out is something and evidence that can be said to be impartial, that can be said to be done by competent professionals around this issue, or competent team, then I think that this is, we should really explore how we can utilize IFEC more than exactly what we are currently doing. In Nigeria, this is something we would love to also explore. And I'm going to also call on all other African countries that are here to also look at the possibility of doing same, since we already have this support out there for us in the international space. Again, thank you, and I'm willing to answer any further questions in terms of if you need more information about the practical things beyond what I have said to you here. But just one sentence, knowing that documentation is very helpful. In advocacy, it is also very helpful in improving the quality of the service and support we provide for victims at even individual level. Thank you again.
Thank you so much, Dr. Uju. This is why we call you doctor, but no, thank you very much. I think that really helped to contextualize a lot the importance of advocacy in our sort of daily advocacy, as well as in legal cases and otherwise. Do we have any questions, comments that anyone wants to contribute?
And James, just while they are doing that, remember the question from Juma Ibrahim, I think was asking about this thing around how do you know the victim has been a victim of protest and the torture or tortured victim. I think what I just want to remind us is again the definition of torture as stated in Article 1. So for example, if in the general terms, I'm not talking about protest now, but in the general term, that what for us is important is that whether this person meets all of the requirements in terms of Article 1. One, was this person tortured, whether physically or psychologically? Two, was the perpetrator, the status of the perpetrator in regards to Article 1 is also important that we need to mention. And of course, the eliminating factor under Article 1 saying that this what the person is complaining of cannot be said to fall within the normal issue about dealing with a sanction that has already been given by a court of competent jurisdiction. So once that happens, it means that this person should be seen as a victim of torture, and then care and support should be given. So in the context of protest, then this is a different matter. But I'm saying that what's really important is not where the torture occurred, provided in this general term, provided that all of those requirements under Article 1 are met. The perpetrator, who the perpetrator is, and what kind of pain and suffering was inflicted.
Great, thank you. Yes, Michelle Kalemba. Michael or Michelle Kalemba, you have a question or a comment you want to contribute? Okay, well, we figure out whether Michelle or Michael Kalemba is going to speak because he has his hand up. Why don't we move on to the final part of this conversation, which is Lionel. I guess we hand the floor to you first, and then Roberto will follow. That's what you just wrote to me, Roberto, on WhatsApp, right? Okay, good. So, Lionel, can we pass the floor to you first? Is it it's not my mic, right?
No,
Lionel?
we can hear you. We can hear you. But
Okay.
Lionel, can you hear us? Or Lionel?
Yeah, sorry.
Ah,
There he is.
there we are. Perfect.
Sorry. Yeah, sorry for the translation. They call Lena. So, yeah, sorry.
Oh.
So, I was waiting for Lena also, but yeah, no.
Right.
Sorry. So, but maybe I will go ahead in French just to let you know for the translation. Merci,
No problem.
Merci à l'IRCT d'abord de recevoir la FIACAT, la Fédération internationale des ACAT, et les membres de son réseau, de leur permettre de participer à cette formation. Je crois que c'est intéressant et ça va dans une logique qui est celle finalement de s'intéresser aux victimes au sens large et finalement de voir aussi la possibilité de pouvoir mutualiser et renforcer les synergies d'action autour du parcours des victimes. Et je crois que c'est là l'intérêt aussi, et où vont mes remerciements à l'IRCT de pouvoir nous permettre aussi de partager nos expériences et nos travaux. Et je me réjouis de voir que quelques membres des ACAT également du continent africain sont présents totalement, et même quelques-uns du continent européen. Pour aller très rapidement, parce que je vois que le temps également défile, par rapport à ces identifications des preuves concernant les victimes de torture, il est vrai, il a été présenté auprès de la Commission africaine des droits de l'homme et des peuples, à travers l'un de ses mécanismes, le Comité pour la prévention de la torture en Afrique, certaines règles.
Lionel, Okay, I'm just gonna stop you here. If you can speak slower so the interpreters can follow up, can keep up with your speed. Thank you.
No. Désolé. I do apologize. Donc, comme je le rappelais, la commission africaine...
Sorry, will it be possible? Sorry, will it be possible just to explain to people how they can get the translation, because I am getting it. So just if you can let them know where to go to, the 3 dots, and so that they can get the translation as it will happen, because there is simultaneous translation I'm getting out. Let them, so if you can explain to them so that they can do that, all of everyone.
Yeah, so in the bar, you're gonna see in the bottom, there's 3 dots and called more. And then here you can see the interpretation button that looks like a glove icon. There you can get to your channel, so French or English.
And press done. If they don't press done, it won't work. And press done.
And press done. Thank you. Sorry, Liolène. You can continue.
Non, aucun problème. C'est bon pour vous, docteur Oujou? Vous entendez? La traduction, OK? Donc, du coup, je vais reprendre peut-être depuis le début, un peu plus lentement également. Donc, je tenais à remercier l'IRCT d'accueillir la FIACAT, la Fédération internationale des ACAT, d'accueillir la fédération. Je voulais remercier l'IRCT de nous accueillir et également son réseau qui démontrait la démarche holistique dans l'approche de soutien aux victimes de torture. Je crois que c'est très important de l'aborder dans tous ces aspects. Nos membres travaillent sur différentes situations, que ce soit dans de liberté ou à d'autres endroits. Et dans ce cadre-là, ce renfort de synergie, il a montré que la société civile était mobilisée autour des victimes, mais parfois pouvait se sentir démunie dans la façon d'alerter ou de toucher les mécanismes internationaux qui pourraient interagir avec la société civile au niveau des mécanismes internationaux et régionaux de promotion et de protection des droits humains. Et dans ce cadre-là, la Commission africaine des droits de l'homme et des peuples, notamment par son mécanisme, le Comité pour la prévention de la torture en Afrique, a décidé de lancer ce qu'ils ont appelé un mécanisme d'alerte qui se rapporte aux situations de torture et actes connexes. Et pour ce faire, ils ont mobilisé plusieurs experts pendant une année, dont les partenaires de l'IRCT, de Dignity, de la FIACAT, de l'OMCT, en tant que représentants de la société civile, et de s'associer au groupe d'experts afin de réfléchir finalement à une sorte d'outil vulgarisé pour permettre à la société civile d'envoyer des informations justement à ce mécanisme-là de façon à ce que lui puisse agir auprès des autorités. Encore une fois, je dirais que ce n'est pas un outil qui est 100% aujourd'hui complet, qui mérite sûrement encore des ajustements, mais qui doit au moins permettre la mise sur pied, je dirais, d'un réseau formalisé d'organismes étatiques, d'institutions nationales des droits de l'homme, d'organisations de la société civile, soutien aux victimes, de pouvoir transmettre des informations. Et à travers ça, encore une fois, via des outils vulgarisés. Tout à l'heure, j'ai entendu effectivement le fait que les fiches de renseignement sous format écrit, etc., étaient des éléments parfois difficiles pour les victimes, notamment au niveau du recueil d'informations. Et nous, on le voit aussi au sein du réseau. Tout à l'heure, Maître Michel voulait prendre la parole de RDC. On reçoit régulièrement sous format vidéo des actes de torture. Et c'est l'idée de savoir comment traiter ces informations pour permettre à minima d'alerter sur la scène internationale et de permettre que ces instances internationales et ou régionales, telles que le CPTA, puissent prendre attache avec les autorités nationales pour qu'il y ait un mécanisme d'alerte. Je n'irai pas plus loin dans l'explication, je vais laisser peut-être ensuite Roberto en parler, mais j'ai vu également que dans ce séminaire, il y avait Eva Nudd qui était là et qui a participé à ces travaux, et toute autre réflexion ou commentaire sont les bienvenus. Moi, je vous invite aussi, peut-être à la suite de ce webinaire, l'outil sera partagé, l'outil vulgarisé, hein, donc ce leaflet sur les règles portant création de ce mécanisme, de comment le saisir, de comment mettre en place ce réseau, comment faire les partenariats, les possibilités de partenariat avec le Comité pour la prévention de la torture en Afrique peuvent être formalisées. J'imagine qu'on pourra le transmettre par la suite, soit dans le chat, soit via email aux participants. Merci.
Thank you very much, Lionel. And now it's quite a bit difficult, I mean, to be the last speaker after all these interventions. And well, the main points regarding my short intervention will be the importance that has been given in the new Abidjan rules about how to submit a complaint to the CPTA and how this complaint should be structured, and more, even more, what if there is any medical, legal evidence to be submitted to the CPTA. So as we can see, I'm sure we are already more than familiar with the CPTA Abidjan rules, and you've seen that the last point, the CPTA is asking if there is a medical legal evidence or photographic evidence of what happened during the events and how it has been reported. So the role, mainly the role of a partnership with IFEG RCT in analyzing what happened during the event suffered by the victims is to strengthen this part, bringing also psychological interviews, medical interviews, a legal perspective in order to submit the complaint and to raise awareness at the CPTA level. What is important is that IFEG is working in collaboration with with local NGOs, and is working in the due respect of the victim, trying to avoid re-traumatization for the victim, and is taking care of what is concerned at a victim level, both from a psychological and medical point of view. Yes, Andres?
Merci. Brièvement, je pense que le thème de la preuve est très important, mais ça ne doit jamais devenir une obsession, parce que ce qui fait la preuve, c'est la vérité, fondamentalement. C'est-à-dire le récit de la personne sur ce qu'il a vécu, sur ses effets, l'authenticité du récit. Ce point-là est fondamental, et dans l'attitude de celui qui fait l'interview, c'est très important, cette orientation. Après coup, le thème de la preuve se pose, mais pas dès le départ. Je pense que c'est très dangereux d'être obsessionné au moment de l'interview. C'est une petite remarque que je voulais faire. Merci.
Okay. No, we completely agree with this. So it's not researching a proof. It's more the work done by IFEG and by RCT. It's about exposing torture. It's not the research focused only on proof of what happened. We are trying to expose torture and to bring perpetrators accountable, to increase the to highlight the responsibility of the perpetrators. And this is why we are working with, we are collaborating with medical experts, with psychologists, psychiatrists, and we are considering all the aspects related to an allegation, torture allegation by victim or by groups, and the documentation is crucial from this point of view. And it is important also for instances like the CPTA at international regional level to deal with the states and to make them accountable for the acts of law enforcement officers in the specific country scenario. So I would, if you don't mind, I would prefer to go through the questions in the chat because I find them. My presentation is really technical and it's mainly a repetition of what has been already said by James, George, Dr. Ujo, and Lionel. So if we can maybe open the floor and discuss the questions in the chat, it would be better, I guess, also from the other participants. Yeah, Lionel? Lionel, tu voulais intervenir?
Simplement en réaction à ce qui a été porté par Andrés, notamment le mécanisme d'alerte auprès du CPTA, c'est effectivement ça, c'est d'abord de poser une situation, d'informer, de le bloquer. Ensuite, il y a tout un temps qui est fait pour la recherche de la preuve, la confirmation des preuves. Donc, il y a tout un outil qui est mis en place avec un timing aussi. Mais d'abord, l'idée, c'est parer à la situation d'urgence. Justement, lorsqu'un membre de la société civile, un lanceur d'alerte, reçoit des vidéos dans le cadre de manifestations, par exemple, de violence ou de torture, de pouvoir très rapidement saisir le mécanisme d'alerte, ensuite laissant un temps pour traiter l'information, pour récolter la preuve auprès des victimes et ensuite de pouvoir monter un dossier. Sachant que ce ne sont pas des procédures juridiques auprès du CPTA. C'est ce qu'il faut bien retenir. Ce sont d'abord des procédures, je dirais, entre guillemets, diplomatiques, c'est-à-dire comment saisir les commissaires de la Commission africaine des droits de l'homme et des peuples pour qu'eux puissent alerter les autorités nationales pour ensuite aller vers cette seconde étape qui demande la récolte des preuves. Merci.
Merci beaucoup, Lionel. So we'll go to, shall we start from the last questions? And yeah, and there is a contribution from Önder. Önder is member of the IFEG steering committee in the chat. I will just read it. So Önder is wanted to highlight that the key strength of IFEG is the important level of legal expertise provided to IFEG by IRCT, and the fact that we are closely collaborating both from a medical point of view, psychological point of view, and legal point of view with local experts in order to adapt our support to local actors, to adapt our support to the needs of local actors and to be aligned to national legislation as well. So the role of ICT, I think, is to support the needs of local actors in improving the laws, national laws, and in exposing torture, and to increase the accountability and to protect the victim and the survivor. I was checking the first. So the first question was from Juma. The first one. I do not know if Juma is still here and if he would like to intervene to open his camera. But I mean, how do you ensure that the person attended is victim of torture in a protest scenario? So how do we evaluate? I guess this one was related mainly to the presentation of a form by Georgia. How do you evaluate when both in terms of IFEG IRCT support and if we use the form presented by Georgia, there is a question related when the events occurred to the victim, in which moment, and why the police or the perpetrators did what they did. So there is a description of events, of the facts, and this is when we can gather information of a situation in which the victim has suffered a violation of his basic rights. And I mean, the the scenario, the form shared by George was, as he said already, was mainly targeted for a given country. So the form can be adapted to different country scenarios and can be adapted by local actors in order to respond to the needs of local actors in their country. The second question was related to South Africa, and it was about the existence of several legislative instruments to prevent torture. However, there is a huge gap in the implementation. How then will the medical and health aspect related to torture be measured if torture itself may not be correctly classified as torture, but as violence?
For that one, I would like to say something maybe to add. One, please, I think that from my own experience, one of the key things perhaps I could recommend to South Africa to do is that there's a need to engage the different professionals. So for example, if you could have a consultative session with the legal and the medical professionals within your country. If you look at Article 4 of the UN Convention Against Torture says that all acts of torture must be criminalized. So you need to be able to, even attempted acts of attempted torture should also be criminalized. So the question here is to be able to see what is being done in South Africa currently, whether it is consistent with the provisions of Article 4 of the UN Convention Against Torture, Cruel, Inhuman, and Degrading Treatment. If it is not, then it's a case for seeking for legislative reform. Okay? Now, but in the interim, while that's happening, you want to also find out whether, in terms of the classification of what the work they're doing, how they can make that link. So to extent that what the acts that have been classified as violence, to what extent was your law currently as applicable, prove that there has been sufficient pain or suffering within the conceptualization of Article 1. Is it psychological? Is it physical? That it's enough to meet the the standards of Article 1. Who had committed it, whether it's a official, somebody acting in official capacity and things like that. So I'm thinking that there's clearly some room for some work on advocacy with some people within the country. And if there's need to do additional reform, you can push for it, but also just make sure that whilst the provision of service, that you are not losing anybody, that every victim requires to be provided support for that, whether irrespective of how that person has been so far classified in quotes in your law. So I don't know whether that's clear, the way I put it. I would also say one thing. For example, in Nigeria, there are some acts which are done by states, non-state actors, yeah? So what the justification in some instances we put, because if you look at Article 1, it talks about acquiescence when you look the other way. So what is the responsibility for the state in terms of preventing non-states actors from doing certain things? So if it is within the full powers of the states, preventing the non-states from doing that act, then we also find a way to justify some intervention around that. Thank you.
Thank you very much, Joe. And well, I guess we are the end of this webinar. James, do you want to add a few words? Okay. So, I mean, from IFEG and IRCT can support your cases, can go with you through your cases. So, Fadili, please.
Bon, c'est pas une question, mais c'est juste présenter les excuses puisqu'on n'a pas si les temps exacts. Parce qu'on a indiqué à 15 heures. On pensait que c'est 15 heures notre heure locale. Nous nous sommes connectés à 15 heures. Malheureusement, nous n'avons trouvé personne en ligne.
Ah, ok, je vois, c'était un malentendu.
Allô?
Oui, vous m'entendez?
Oui, je suis en train de... il y a derrière quelqu'un, il y a quelqu'un qui est en train de parler. Hein?
Donc, c'était un malentendu, je crois, parce que dans les mails, on avait bien précisé qu'il s'agissait à 15
Est-ce qu'on
heures.
peut continuer?
Oui, nous avons
Allô?
indiqué que
On peut continuer?
c'était l'heure d'Europe centrale. Well, I think we can move on to the next question.
Ouais. Donc, sorry. So,
Je disais, vous m'entendez?
oui, pas? Oui.
Vous m'entendez?
Oui, et il y a un peu de bruit derrière vous, on vous entend
Oui,
un peu mal.
je trouve qu'il y a des bruits, je trouve qu'il y a des bruits vraiment. On ne sait pas c'est qui a ouvert
Sorry,
son micro.
I guess we can hear the translator, but maybe the microphone is on for the translator.
You think so?
Yeah. Voilà.
Ouais.
Ah,
Ça va en ce
d'accord.
moment?
Roberto,
Oui.
je disais, on n'a pas eu le temps, on n'a pas connu le vrai temps.
Oui, bon, c'est dommage, mais par contre, vous ne vous inquiétez pas parce que le webinaire il est enregistré, il est disponible sur le site fab.org. Donc, quand vous avez le temps, vous pouvez le visionner et après revenir vers moi et James avec des questions, on sera là pour vous. Ce n'est pas un souci. Mais si vous avez une question maintenant, n'hésitez pas à le partager avec nous.
Ah, d'accord. C'était bon. En fait, nous sommes venus, nous avons pris à court, on a passé réellement s'il y a quelque chose comme un résumé de ce webinaire.
Oui,
Si
il y a l'enregistrement, on va partager avec vous le lien.
Ah, bien sûr, bien sûr. Nous serons très, très heureux. Nous serons très heureux. Malheureusement, nous sommes venus en retard puisqu'on ne savait pas. Nous, on savait que c'était 18 h notre temps ici, c'est-à-dire 6 p.m.
Ouais, donc il n'y a pas de souci. Well, I would say that it's time to close the session. And so please do not hesitate to get in touch with us, with James and myself, if you want to discuss further about IFAG and RCT and to submit to us cases to be reviewed, also in light of the new CPTA Abidjan rules. And thank you very much for your attention and your contribution.
Thank you so much. And I will just put here in the chat that the recording will be uploaded on Fabo on our e-learning site. I'll just put the link here. I know, James, if you want to conclude some very smart concluding remarks.
No, thank you, everyone. Yes, Lionel?
Thank you, everyone. Bye.
Okay, thank you, everyone. Perfect conclusion.
Oh, thank
Brief.
you. Thank you, Berta.
James, was that your concluding session? Was that a concluding remark, James?
He's very brief.
Okay. Okay, thank you, everyone. Thank you,
Yes,
IRCT. Thank you,
Thank you,
IFAG.
everyone.
So we look
Bye.
forward for future ones. Thank you.
Thank you.
Yes, thank you, everyone.